I understand that you've recently been appointed by the court to serve as a conservator for an individual with a disability. First of all, thank you so much for being willing to help someone who really needs you. Now, in the state of Tennessee, every conservatorship is individually tailored to meet the needs of the person with the disability, who's called the respondent. What this means is that what you are to do as a conservator can vary from case to case. It is important to note that a conservatorship is not a total takeover of the person with a disability, but rather a conservator is to serve as an agent. The conservator is simply there to help the person with a disability make decisions he or she can no longer make for themselves, as determined by the court. When trying to determine what to do as a conservator, a good place to start is by looking at your letters of conservatorship in the court order. You can get a copy of those documents in the probate court clerk's office. If power or authority over something is not transferred in the letters of conservatorship or in a court order, then the person with the disability retains that power and the conservator does not have the authority to make the decision or take the action. Now let's take a look at a couple of examples of types of rights that may be transferred, but please remember that these examples may not apply to you. Please look at the court orders in your case and talk with your attorney about your specific responsibilities. By way of example, a court order may transfer to the conservator the authority to consent to or withhold consent to any residential or custodial placement. So, for example, if the court transferred this specific authority to you, you have the ability to find the person with the disability a place to live, and you are permitted to sign whatever documents are needed to facilitate that transition. Another example of authority the court may transfer to the conservator is the authority to dispose of property subject to statutory and judicial constraints. Dispose, of course, does not mean to throw it away, but rather means to transfer it somehow through sale or gift. Now it also says subject to statutory and judicial constraints, which means the law. So subject to whatever the law says, you have the authority to transfer property. This is a really good example of something that you'll want to talk to your attorney about. In this case, the law says that you must get the judge's permission specifically prior to transferring real estate. In addition to the letters of conservatorship and the court orders, the property management plan is another great place to look in determining what to do as a court-appointed conservator. The property management plan is a court-approved budget that includes things such as the respondent's income and expenses. So when looking for guidance on how to proceed as a conservator, the property management plan is another good place to look without having to seek additional court permission for what the court has already approved in the property management plan. In addition to the property management plan and the order establishing the conservatorship, as time goes on, things can change, and there might be additional court orders that are entered that change what your powers and responsibilities are as a conservator. So make sure to review additional court orders as they may be entered by the court, and ask your attorney for clarification on how the additional court orders impact your responsibilities as a conservator. Something else that can change as time goes on are income and expenses. If there are any changes with the respondent's income and expenses, make sure to talk with your attorney about submitting an updated property management plan to get the court's permission before any changes to the budget are implemented. We've talked about powers that may be transferred to a conservator. On the other hand, there are some things that a conservator should never do without court pre-approval. For example, the conservator should never take any money or property that belongs to the respondent. The conservator should never transfer any of the respondent's property valued over $1,000 other than a vehicle, and the conservator should never transfer any real estate. Additionally, the respondent usually retains the right to vote. If you have any questions about your powers and responsibilities, contact your lawyer for clarification. It's also a good idea to get permission from the court if it is unclear whether you were given certain authority. Your attorney can help with this process by filing a motion with the court to take needed action, or by filing a petition to expand the authority you've been given if you need additional power to help the person with a disability. Unless there is an emergency, it usually takes a couple of weeks before you are able to go to court to have your motion or your petition heard. So make sure to let your attorney know as soon as you are aware of a specific need. Lastly, as conservator, you will need a way to demonstrate that you are the court-appointed conservator. This can be done through your letters of conservatorship. Depending on the financial institution or agency, you may need to get a certified copy of the letters of conservatorship from the probate court clerk's office. Also, you can pick up a copy of the fiduciary instructions handout at the probate court clerk's office. Now, these instructions, as well as this video, are not intended to be legal advice and should not be relied upon as such. In summary, if you have any legal questions, make sure to contact your attorney. Remember, if the court did not give you power to make certain decisions, you do not have the authority to do so. Also, the letters of conservatorship are the document you need to demonstrate that the court gave you power to make decisions for the person with a disability. And most importantly, remember that if in doubt, make sure to ask the court's permission. Again, thank you so much for your service as a court-appointed conservator.